webcast as well?
Yes, I am. Starting the stream now.
Perfect. Good morning. Happy Monday. Welcome to the Joint Standing Committee on Labor and Housing. My name is Craig Hickman. I represent Senate District 14, 11 towns in Southern Kennebec County. Today, our agenda is full. Hopefully it will be the last long day. We have a public hearing on our agenda this morning, followed by a presentation from the Department of Labor on the change package sponsored by Governor Mills. We'll have a break and then we'll come back and we'll work several bills this afternoon. So with that, let's begin with committee introductions. Today, I'll start with Representative Pepworth.
Thank you, Mr. Chair. Good morning, everyone. Sarah Pepworth, I represent House District 133 in the Blue Hill Peninsula.
Representative Bradstreet.
Good morning. I am Representative Dick Bradstreet from House District 80, and that's made up of Vassalboro, Windsor, Somerville, and part of Augusta.
Representative Geer.
Thank you, Mr. Chair. I apologize. I've got a printer making noise in the background here. Tracy Geer, I represent House District 9, which is Kennebunkport and Coastal Biddeford and Kennebunk.
Representative Drinkwater.
Greetings from the damnedest town in the state of Maine. I'm Gary Drinkwater, representative of District 121.
Representative Rader.
Good morning. I'm Amy Rader. I represent District 125, which is a portion of Bangor.
Representative Cuddy.
And good morning. My name is Scott Cuddy. I represent House District 98, and that is Winterport, Frankfort, Searsport, and Swanville.
Representative Warren.
Good morning, I'm Sophie Warren and I represent Scarborough Coastal District 29.
And we also have with us today our Dream Team analysts, Mr. Stephen Langland and Ms. Alyssa Thompson. It looks like, Mr. Langland, we do have, I believe, the Senate President is here. So, Chairman Sylvester must introduce himself. I forgot, pardon me, it's Monday, and then we'll go into public hearing. Chairman Sylvester.
It's Monday. Hi, I'm Mike. I'm the chair of this committee. I represent a piece of Portland and the best part of Portland. And then otherwise than that, I will be the timer today. So if folks who are testifying would put their view into gallery, I'm going to be holding up my little phone when you start speaking. You got 3 minutes. At 30 seconds, I'll hold it back up so you can see the countdown. And then the chairman and I will gently nudge you to finish your thoughts.
Thank you, Chairman, and I apologize. I usually go to you last, and I just forgot today for some reason because we just spoke. So there you go. So with that, I see the Senate President is here. We will welcome him to the panel to present LD 677, an act to public sector labor relations by amending the laws governing arbitration under certain public employees' labor relations laws.
Thank you.
Yours, yours. Good morning.
Thank you, Senator Hickman and Representative Sylvester and the esteemed members of the Joint Committee on Labor and Housing. As you know, my name is Troy Jackson. And I represent the good people of Northern Mercer County and Senate District. I'm here to proudly present LD 677, an act to improve public sector labor relations by amending the laws governing arbitration under certain public employees' labor relations laws. So this bill, like many others you've seen this session, is not new. In fact, I think the first time that I heard this bill, the first time I had any understanding of buying arbitration was all the way back in 2003, the 121st, when I served on this committee. It deals with public employees in the legislative, executive, and judicial branches, as well as municipal employees. It's an attempt to protect your constituents, who teach our children, who prepare our committee work, who keep our offices safe and clean, who protect our streets and county lanes, in other words, who make our jobs as legislators possible. The basics of LD 677 are as follows. In the public sector, the parties cannot reach a contract. There is a process that involves mediation, fact-finding, and then arbitration. Under current law, when entities in the public sector enter arbitration, the agreement reached at the end of the process is not binding for the most significant issues. For example, Agreements on salary, insurance, and retirement benefits are not binding, even after arbitration. As a result, neither management nor employees have any incentive to keep their end of the bargain. I think our public employees, our teachers, our firefighters, and snowplow drivers deserve better than this. With that in mind, I'd like to share some background on the proposed legislation. This bill passed both the House and Senate in the 129th session. Unfortunately, for the public employees that it aimed to protect, it was vetoed by the governor. Her objection to the bill was based on two specific considerations. One had to do with assuring that arbitrators were neutral and understood how our state works. The other dealt with timing, making sure the public entities involved had time to react to the changes agreed upon in the contract. And I can assure you both of these concerns have been addressed. With regard to the concern about neutral arbitrators, ones who understand our state and those who work for it, the bill gives the governor the power to appoint a panel of impartial arbitrators who must reside in the state. This eliminates the concern of hiring private arbitrators from out of state. To address the concern regarding the timing of contracts and the implications of those contracts, the bill assures that cost items in any arbitrated agreement are not included in the operating budget for the fiscal year that is ratified. This in mind gives more than ample time to consider the fiscal implications of a new contract. Also, it is important to remember that this legislation only comes into play when parties meet, discuss, and disagree, when they dig deep into the issues and cannot reach an agreement. To be clear, this is a rather simple but important bill. It's about making sure that the outcomes reached through arbitration mean something for both management and workers in the public sector. It's about giving workers and employees assurance when a good faith negotiation has been reached. And that basically is why I think this bill is very important. I do not understand why anyone, either side, in any negotiation would go forward in arbitration if in the end you win and you don't have any ability to influence what you actually want. That seems like a waste of taxpayers' money. Seems like a waste of the process. I am more than happy to go forward in any negotiation, and if it gets to a point where we agree to have mediation, if the arbitrator decides, that should be binding on either side. And unfortunately, that isn't the case now, and that's why I believe this bill is important. We've definitely worked to try and make it better for issues that were brought up after the bill was vetoed a couple years ago. And with that, I'll try and answer any questions that you may have.
Thank you, President Jackson, for presenting the bill. Before we turn to committee questions, let's turn to some more introductions. I see Senator Guerin has arrived. Please introduce yourself.
Good morning. I am Senator Guerin, representing the beautifully sunny Southern Penobscot County District Senate 10.
Thank you. Senator Miramont.
Good morning. Dave Miramont, Senate District 12, Knox County, with the county seat of Rockland.
And Representative Morris.
Good morning. I'm State Representative Joshua Morris. I represent House District 75, which is Turner, Leeds, and Livermore.
Thank you all. Chair recognizes Representative Bradstreet for a question.
Thank you, Mr. Chair. Good morning, Senator. Thank you for being here. I think you mentioned in your testimony, one of the reasons the governor vetoed the bill coming out of the 129th was that an out-of-state arbitrator could make decisions for Maine localities. And I'm trying to think back, and was it the fact that it was an out-of-state arbitrator, or is it arbitration, binding arbitration in particular that she was opposed to? And she was just citing out-of-state arbitrators as an example of what might happen.
Representative Bradstreet, great question. I don't actually know, can't tell you. I mean, you're asking me for opinion on why the governor vetoed it. All I can do is go from the letter that we all received. But if that was the concerns, we definitely tried to address them in this year's legislation, and that's all I can tell you on that, sir.
Okay, very good. Thank you.
Are there any other questions for President Jackson from the committee? I see Mr. Langman has put in the veto letter to our chat for the committee to see. The testimony can also be found there as well. President Jackson, it looks like you're going to get let off the hook rather gently. No one has any more questions for you, so thank you for taking the time to come and present your bill today. I will now take testimony from the public. I can see that most of the people signed up on this bill in favor and against are professional testifiers, for lack of a better phrase, so I don't have to go into the spiel about how to present that under 3 minutes. Don't use the chat box or anything other than technical issues. Today, we're going to start with testimony in favor of LD 677 and end with testimony opposed to it. There are almost an even number of people signed up for both. So today, the last shall be first. Ms. Thompson, we're going to go William Doyle, please, if you could let him in. Then Tom Feely, and then Mr. Paul Gasper, followed by Michael Kraus, John Kaczynski, Jim Durkin, Carol Sanborn, and Adam Good. As people come through the wormhole, we will be patient. I see William Doyle's name on the screen. Mr. Doyle, there you are. Welcome. You may begin your 3-minute testimony, sir.
Good morning, welcome. I don't know that I'm a professional speaker, but I'll do my best here. Senator Hickman, Representative Sylvester, and distinguished members of the Labor and Housing Committee. My name is William Doyle. I currently serve in the capacity as Regional Director for the National Correctional Employees Union, NCEU. Prior to serving in this capacity, I worked as a corrections officer in Southern Maine. The National Correctional Employees Union represents approximately 2,000 members from Maine to Pennsylvania. Specifically in Maine, the NCU represents 9 out of the 15 county correctional units and 2 communication units made up of approximately 650 members. We are here today in strong support of LD 677. Public safety jobs are facing devastating staffing shortages. Ask yourself, would you want to be a communications, corrections, police, or fire officer during the present time? The answer is I respect and thank them for what they do, but no, that's all the more reason to support this legislation. Currently, there are approximately 80 positions vacant in the Maine State Correctional System, 66 positions vacant at Cumberland County Jail, and 35 positions vacant at the York County Jail. Without corrections officers, the entire criminal justice system fails. If you're dismissing that statement, ask yourself, who will oversee and rehabilitate incarcerated individuals? Corrections employees with the seniority and rank are leaving the job to take jobs at both Bath and Kittery shipyards, General Dynamics, Pratt & Whitney, and other miscellaneous locations. Some of this is due to short-sightedness of public officials who are penny wise, pound foolish, as the old expression goes. Current Labor Relations Act unfairly places municipal employees, including county communications and correctional officers, at a disadvantage when it comes to the collective bargaining process. Realistically, it should be called collective begging. Unions are faced with a difficult task of getting the best wages, benefits, and working conditions for their members under the collective begging system. Public safety employees are prohibited from striking or other concerted activities, so the employer, after some process, has the right to implement their last, best, and final offer with regard to wages, healthcare, and pensions. When one party holds all the power, the other party is forced to make concessions in order to get simple cost of living adjustments or COLAs. As we understand it, this bill will add binding arbitrations on wages, healthcare, and pensions for municipal as well as other employees. We wholeheartedly support the bill and believe it will level the field for collective bargaining with employers. Binding arbitration by itself will upend the apple cart or bankrupt communities. These are scare tactics designed to maintain the status quo. Current bill before you has several factors that arbitrators have to take into consideration when coming up with a decision. Many of the determining factors identified are costs to the employer, comparable compensation in the area, as well as overall wages and benefits complete package. These determining factors alone will minimize the potential for the union or public employee windfalls, as they call it. Bottom line is, if you want to keep people, You have to pay them their fair and equitable wage to the current market.
Doyle,
Yes.
unfortunately, that is the end of your 3 minutes. I wonder if you could summarize your thoughts.
The NCU is wholeheartedly in favor of LD 677. Happy to take any questions. Thank you.
Thank you, Mr. Doyle, for your testimony today. Are there any questions from the committee? Seeing none, thank you for being here, sir.
Thank you.
Mr. Tom Feely, the floor is yours.
Good morning, Senator Hickman, Representative Sylvester, and members of the committee. I'm Tom Feely. I am General Counsel of MSEA Local 1989 SEIU. Like Mr. Doyle, I am not a, I just got a message. Like Mr. Doyle, I'm not a professional testifier, but it is my privilege to give you all a break from Jeff McCabe today. 2 years ago, I came and testified in support of this same bill, arguing that our state labor laws gave public employers an unfair advantage at the bargaining table and hamstring workers' abilities to negotiate better economic deals. Currently, the employer consists on a hardline economic package, and if no agreement is reached, the employer can simply implement their last and best offer and force workers to accept wages that are below market level. Over the long term, I argued, the uneven playing field on economic items would lead to depressed wages for public sector workers. Now we have data showing that this is in fact the case. Last year, pursuant to an agreement with MSEA, the state of Maine hired an independent consultant to study the compensation of state workers versus those of its largest competitors. The results of this study are jarring. State employees make on average between 15 to 20% less than their counterparts working for the state's closest competitors. Even at the top of the pay scale, accountants for the state of Maine make between 20 and 33% less than their peers working elsewhere in the region. Chemists make 24% less. Civil engineers make 20 to 25% less. Maintenance mechanics make 31% less. Administrative workers make between 20 to 35% less. Rehabilitation counselors make 25% less. Correctional officers make 16% less, and correctional captains make 26% less than their counterparts. For 40 plus years, public sector workers have had to collectively bargain in a closed system, completely severed from the free market. The state employee wages I have just discussed, and which you can review for yourself, are the direct result of this unfair system. Senator Jackson's bill would even the playing field, and in do so would foster the spirit of collaboration and compromise in negotiations. Binding interest arbitration means that both parties know that at the end of the day, they will have to justify their bargaining positions before a neutral arbitrator who would be empowered to resolve bargaining disputes and make contract language. This threat forces parties to make reasonable and justifiable proposals and to avoid insistence on irrational or ideological positions. This legislation would help us negotiate wages and economic packages that would both keep the functions of government running strong and provide an economic lift to our workers, their families, and their communities. We ask you to vote in favor of this legislation. Thank you, and I would be glad to answer any questions.
Thank you, Mr. Feely. Are there any questions from the committee? Seeing none, thanks for being here this morning, sir, and providing your testimony. Next up is Mr. Paul Gaspar, followed by Mr. Michael Kraus and Mr. John Kaczynski. Mr. Gaspar, are you there?
Yes, I am.
Great, the floor is yours, sir.
Fantastic, thank you. Good morning, Senator Hickman, Representative Sylvester, members of the committee. And no offense to Mr. Feely, but I was kind of hoping to see Jeff McCabe, but I'll give him a call later. My name is Paul Gaspar, and I live in South Portland, and I'm proud to be before you on behalf of the Maine Law Enforcement Coalition. The coalition and its member organizations represents about 3,000 state, county, and municipal law enforcement officers and public safety dispatchers throughout the state of Maine. On behalf of the coalition and the organizations and memberships throughout the state, I'm here to offer strong support for LD 677, an act to improve sector labor relations by amending the laws governing arbitration under certain public employees' labor relations law. The passage of this bill will give Maine's public safety employees an opportunity to level the playing field when they engage their employers in the collective bargaining process. Under the current system, public safety employees who are negotiating for better salaries, retirement, or health care can be denied benefits by an employer who knows that drawing out the process, going to fact-finding, and subsequently to the arbitration process will result in a recommendation only. And it's important that this is in all economic matters under the contract. The employer can ignore the arbitrator's decision as it relates to economic issues and impose last best offer onto its employees. Passage of 677 and providing for binding arbitration will provide a meaningful and fair arbitration process that will provide the employees the ability to resolve disputes and have them be binding on both parties in its disposition. For those committed individuals who place themselves in harm's way in the interest of justice, the current system allows for a hearing before an objective and independent panel or arbitrator. However, should the matter concern a vital economic impact on the employee's contract and livelihood, justice under the contract and labor law is denied. The ability for a municipality to not be held accountable in the wake of a decision against them by an independent arbitrator erodes the very basis of fairness and accountability under the laws established to ensure exactly that. Every day, our public safety employees should be able to report for duty without feeling limited in their ability to improve their jobs and the services they provide for their community. These are the people who have committed their lives answering the call to protect our neighborhoods and communities, to find the missing loved one, and to be where they are needed the most. They deserve a minimum expectation that they have a fair set of rules when bargaining to improve the services they provide and the quality of service they provide to others. So we ask for your support on LD 677, and I'm happy to answer any questions.
Thank you, Mr. Gaspar, for your testimony this morning. Are there any questions from the committee? Seeing none, it's a breezy, easy Monday.
Thank you. Have a good day.
You too. Mr. Kraus, Mr. Michael Kraus, you will be next, followed by John Kaczynski, Jim Durkin, Carol Sanborn, and Adam Good. Mr. Kraus, the floor belongs to you. Are you here with us?
Looks like Mr. Kraus left.
Okay. So next would be John Kaczynski. Good morning.
Good morning. Senator Hickman, Representative Sylvester, and other esteemed members of the Labor and Housing Committee. My name is John Kaczynski. I'm here on behalf of the Maine Education Association to testify in support of LD 677. The MEA represents teachers and other educators in our state's public schools, a charter school, and the faculty and professional staff in the University of Maine community college systems. This bill will impact nearly every single member of the MEA, all 24,000 of them. It will positively impact every public school employee in the state and every faculty and staff member in our state's public higher education institutions. Might not generate a lot of press attention, probably won't be featured on tonight's news, but it has the potential to fundamentally improve the lives of thousands of public educators in our state by finally leveling the playing field between management and public employees and requiring matters of collective bargaining to be potentially subject to binding arbitration. As you heard, currently the public employer and union negotiate together. The parties cannot reach agreement. There is a dispute resolution process. Parties go to mediation, fact-finding, and finally to arbitration. Arbitration is binding on all issues except for salary, insurance, and pension. After arbitration, if impasse is reached and the parties cannot reach agreement, the employer can unilaterally impose salary, insurance, and pension terms on the workers. During nearly every contract discussion, teachers and public school employees are reminded of the current imbalance and unfairness in our labor law. We are reminded, often by the Council for Management, that they hold the ability to unilaterally implement wages and health insurance benefits, unilaterally. We can impose what we want, is a phrase often heard in negotiations in the public sector. The current unfairness in our law is demoralizing. But the unfairness in current law is not just theoretical. The impact on employees and public education is real. For example, in MSTAD 58, Mount Abram, during negotiations 2 contracts ago, the school board exhausted the dispute resolution process currently in law and then imposed a salary scale that resulted in large decreases in salary for some and a flight of teachers away from the district ensued. I would encourage anyone that knows teachers in SAD 58 to give them a call and hear how they respond. In 2014, in RSU 4, the district imposed their own salary scale after exhausting the dispute resolution. And the only thing the local association could do is add a line in the contract noting they object to the salary scale and its imposition. 4 years ago, a group of nurses in SAD 6 joined the MEA, and after 2 years of negotiations, they were elated when both the fact-finding and arbitration panels agreed with the association's position on the salary scale. Yet, the school board there refused both panels' reports and imposed the salary scale they wanted all along. This situation represented perhaps the latest example of the unfairness. Even more alarming is in the impositions is the trend of emboldened employers cropping up in places around the state on the heels with this message. This is what we want on salary and health insurance. Association, you cannot get a binding decision and we get to impose at the end of the day, so why fight? A few rounds of negotiations.
Mr. Kaczynski?
Yes.
Unfortunately, that is the end of your 3 minutes. I wonder if you could summarize your thoughts.
So my last point was just University of Maine, we struggled to raise salaries. I want to point out that 300 employees at the University of Maine system are eligible for, are actually enrolled in Medicaid. They're the 6th largest employer in the state of working adult Medicaid enrollees. We have over 100 employees enrolled in SNAP. We will struggle to raise wages and benefits for those workers without LD 677. And we believe this will result in a swifter resolution of union contracts in the future. Thank you for your time.
Thank you, Mr. Kaczynski. There are questions for you. Chair recognizes.
How did I get all the questions, sir?
Always get all the questions, sir. Chair recognizes Representative Pebworth.
Thank you, Mr. Chair. Thank you, Mr. Kaczynski. You gave us a few examples, which was helpful. And I'm curious what your expectation would be going forward of how many situations we would expect to see this come up in.
I think there will be a lot fewer situations that we will get to this place. I think in the 3 examples that I provided, SAD 58, RSU 4, and SAD 6, in all 3 of those examples, there was some indication along the bargaining process that the council and the school board knew if they exhausted the process, they could implement what they wanted. And with the passage of LD 67, that's why I didn't get to it, unfortunately, in my last point, I believe it will result in swifter resolution of contracts because we won't see school boards try to exhaust the process currently so they can impose what they want in the end anyway. Does that answer your question, Representative Pebworth?
It does. Thank you.
Chair recognizes Representative Rader.
Thank you so much, Mr. Chair. Thank you, Mr. Kaczynski, for being here. This might be a bit of a self-serving question as I am part-time faculty at the University of Maine. And my question is that this would then affect the part-time / adjunct faculty at UMaine. And do you happen to know if the Part-Time Faculty Association is in agreement with the MEA in terms of this bill?
I can't see any. I don't know for certain. That would be a great question for Mr. Feely, I believe, because they represent the part-time faculty. But I would struggle to see why they would have any opposition to this in terms of just leveling the playing field for all public sector employees. So I struggle to see why any public sector employee or labor organization representing public sector employees would have any opposition to this bill.
Great. Thank you so much.
Thank you.
Recognizes Representative Bradstreet.
Thank you, Mr. Chair. Thank you, Mr. Kaczynski, for being here again. Good to see you.
Good to see you, sir.
Under binding arbitration, is the arbitrator required to take either the one offer or the other, or are they able to negotiate something in between?
They're able to negotiate something in between, sir.
Okay, they can. Good. Thank you.
Yep. And what I really like about LD 677, if you read the bill, there are several provisions in the bill that stipulate what the arbitrators have to use. It has criteria in the bill, including evaluating similar employees, evaluating the ability for the employer to pay. If you look inside the bill, sir, it actually stipulates even further what the arbitrators are required to use before rendering a decision.
Chair recognizes Representative Morris.
Thank you, Mr. Chair. You've talked a lot about the school boards and so forth. And as you know, school boards are elected by the people of these districts. So I guess the question is, if Because certainly we hear from the teachers in our communities when they're not happy with things. Why aren't the people changing these school boards if, they're not happy with the way they're negotiating the contracts?
Well, I will say that has happened quite a bit, sir, and I can point to examples of that. I definitely know of plenty of local associations around the state who are actively involved in recruiting school board candidates, in evaluating school board candidates, and helping to elect great people to be on school boards. What I would say happens here most of the time is what we're seeing is school board councils who are providing counsel to school boards that serves to delay a resolution of a contract and serves to inform the school board members that they don't have to negotiate. At the end of the day, the most important elements of a contract for working people typically are wages and health insurance. And through the school board council, they are informing school board members that if they simply delay and drag this out, they can go ahead and impose what they want. So that's going to continue to happen regardless of who's sitting in those seats, as long as we have the current arrangement.
Chair recognizes Chairman Sylvester.
Thank you, Mr. Chair. Mr. Kaczynski, you anticipated my question about private counsel. However, the second question I was going to ask is about the subtlety of negotiations, that when things bog down in one place, other pieces of the contract don't tend to get the attention that they might need. And we certainly want you to be negotiating over, making sure that educators have the proper tools, that they have the proper training, that they have the proper time. But things tend to get bogged down on insurance and pay. And sometimes I'm wondering what you think that might do to free up some of these issues to really be able to dig in on those in a way that, if 60% of your time is spent on insurance and pay, and fair offers aren't put on the table, whether that will help some of the complaints that people have, particularly educators about these negotiations.
It may. There is yeah, thank you, sir. I mean, there's the bill before you, LD 52, which is making its way through the chambers, which will be huge for educators by simply moving one of the key issues, particularly for teachers, planning and prep time, from a prohibited subject of negotiation to a permissive. And that's one of the key issues. But I would agree with what we're trying in situations where we have counsel encouraging school boards to exhaust the process to implement. It does so much damage in those relationships, in those communities. I didn't put in my written testimony, but I would really encourage, if you know someone who teaches or taught in SAD 58, give them a call and ask them how damaging this was, or in RSU 4, how damaging this was when they exhaust the process. So it certainly has an impact on the subjects of negotiation, but when this happens, it just ruins labor management relationships in a way that it's hard to overcome many years later. And yet our goal as an association is collaboration with the employers. And when you see this happen time and time again now, it ruins the collaborative atmosphere and makes it us versus them. And we're going to do this because we can. And it's just not good for schools. It's not good for higher ed. And it's certainly not good for educators and students. I hope that answers your question, sir.
It does.
Chair recognizes Representative Drinkwater.
Good morning, Mr. Kaczynski. Nice to see you from a distance. Listen, isn't it a right now when the two sides cannot get together that they can request arbitration?
Yes, sir.
And the difference, I think, between what we're reading for a bill and what is presently in place is who pays for the arbitration under current law?
I don't believe that's the subject of this bill, sir. The current, as I explained in my testimony, the process is if two parties, if we're negotiating with a school board and we can't reach resolution, the first step is mediation. Mediator comes in. And I've been in these negotiations where the mediator says, I can't help you. You're too far apart. School board's not budging. You got to go to the next phase. Next phase is fact finding. You go through fact finding, 3-person panel, 1 neutral, 1 employer rep, 1 employee rep. You make your case. Fact finders come out and say, here's what we believe would be a good resolution of this contract. No, neither side has to agree to what the fact finder says. Then it goes to arbitration. So if you can't agree there, you go to arbitration. Again, arbitration panel, one employer rep, one employee rep, and a neutral. And what happens, what this bill is trying to address is the problem where all matters under discussion are binding under current law, sir. It's not a question of who pays for the arbitrator. This bill says currently all matters are binding except in current law, it says salary, health insurance, and retirement. Retirement's not a big issue for us because that's managed through MEPers, generally speaking. But for the other two issues, salary and health insurance, even if an arbitrator, as was the case in Set 6, agrees with our proposal and says that proposal is fair, that proposal is good. In that situation, the school board can say, we don't agree. We're going to implement our own. And that's what's happened in the cases I provided you, sir.
So isn't it true that right now under arbitration that the teachers union and the administrative unit has to pay for arbitration?
Yes, sir, the cost of the arbitration, but that's not what the subject of
No,
this.
no, so just follow me for a second.
Okay.
So having known that isn't it expensive to go through the arbitration process?
Yes, sir, we'd like to avoid it at all costs and get to a better resolution in a swifter manner, and we think this bill will do that.
Thank you.
It does not behoove either side to go to arbitration. It behooves both sides to work together, collaborate, and come up with a fair agreement.
Are there any other questions for Mr. Kaczynski? Seeing none, thank you, sir.
I told you I'd get all the questions.
Yes, always. Next up is Mr. Jim Durkin.
Thank you, Mr. Chairman, members of the committee. Can you hear me okay? Hello? Mr. Chairman?
We can hear you, Jim.
Thank you. For the record, Jim Durkin here on behalf of AFSCME Council 93 and our more than 2,600 public sector workers in Maine to express our strong support for LD 677. And we want to thank Senate President Jackson for filing this legislation and perhaps most importantly, soundly addressing the two concerns that led Governor Mills to veto the legislation in the last session. I'm going to be brief as possible today because I know it's going to be a long day and there's really not much more I can add to the testimony already delivered by my brothers and sisters in the labor movement. Suffice to say that as much as we want to see this legislation become law, it would be our hope that we would never have to use it, laying aside for a moment the claim that management does in fact use the current toothless process to draw out negotiations and wear down the union by forcing us to expend time and resources. We think it's fair to say for the most part that neither party wants to see contract negotiations head to arbitration. I can assure you that's the case from a union perspective, because if we are in arbitration, that means that before we get to that point, we've been through months of negotiations, followed by formal mediation, followed by another formal process known as fact-finding. And all of this involves a great deal of time and the expenditure of precious and limited union resources. Meanwhile, most importantly, our members are working without a negotiated pay increase needed to help them keep pace with the rising cost of living, and they're living with uncertainty regarding their health insurance coverage, what it will cover and what it will cost. But to be clear, while we hope to never hit the need to get to arbitration, we always stand ready to go the distance in the interest of securing a fair and equitable contract for our members. We're ready to run that marathon. We just want the finish line to be real and not a mirage that loops us back to the starting line. If we do exhaust all other remedies and get to the point where the review and input from independent, fair-minded professional arbitrators, we want that process to mean something more than just another opinion that one side was right or wrong, because right now that's all it is. It's an opinion. It's a fair and balanced opinion, again, arrived at by independent, experienced professionals armed with all the facts. But right now, it's just an opinion that can be folded up and tucked away in a file cabinet. And I'll close with this. As I said at the onset of my remarks, our union never wants to get to the point of needing the assistance of arbitrators. So it stands to reason that we, of course, would never want to get to the point of calling for a strike. But if you believe, as we do, that the arbitration process should be binding on both parties, then we believe we should also provide workers with the recourse they need in the event that a public employer simply refuses to effectuate the binding decision of arbitrators in the form of a contract. I thank you for your consideration and I'll do my best to answer any questions you may have.
Thank you, Mr. Durkin. I apologize for finding out on mute since I was asking, but I'm happy to have you here today to testify. Are there any questions for Mr. Durkin from me? Seeing none, thank you very much. And
thank you, sir.
Carol Sanborn is next, followed by Mr. Adam Good. Ms. Sanborn, are you here with us?
I am. I am trying to start my video.
Let's see. How's that? There you are.
Can you hear me?
Yes, we can see you as well.
Good morning. I'm Carol Sanborn, a resident of Dresden, and am president of Local S89 of the Machinists Union. We have 8 bargaining units in 4 counties, and 6 of them are public sector. This bill is one of the rare nonpartisan opportunities that we all have to help Republicans, Democrats, Independents, and others, in addition to the taxpayers. Our public sector workers in Maine cover all spectrums. Arbitration is a tool used to resolve disagreements. It's a tool of last resort, as others have said. No one wants to end up in arbitration, other than perhaps municipal attorneys who get paid more the longer this goes on. When an impasse is reached, the parties can agree to hold a private meeting with an arbitrator who is an independent third party who functions as a judge in the proceeding. The parties share the cost and both sides must agree to the person. The arbitrator listens to both perspectives and importantly considers any limitations on resources that the municipalities may have and will ultimately issue a decision. When the parties know they're bound by the decision of a third party, they both try harder to first reach agreement between themselves. And when this happens, it's more likely that a compromise agreement will be reached without the need for an arbitrator. Arbitrations will decrease in number if this bill is passed. Regarding economic issues, as others have said, currently, we will end up with only a recommendation, an advisory opinion, or a suggestion, if you will. Municipal administrators are getting paid with our tax dollars, yours, mine, everyone's tax dollars. They're using our own resources against us and create endless delay, which is very costly to all of us. You and I and the public sector workers themselves provide these managers with the money that they are using to finance the debate. There's no accountability in this regard for them, and employees are left hanging for months to end up with only a written suggestion. Our members simply want to work and be paid a reasonable wage in exchange for their time. Again, it's not partisan, we all pay taxes. Supporting binding arbitration on all issues for public sector workers would not actually give these workers anything other than the right to an impartial hearing. You're not voting to give them money, you're just voting whether to allow them to have an impartial hearing. It allows them, or would allow them, to participate in a democratic process that is revered by all Americans. Our current system needs to be reformed to increase efficiency, reduce costs to both parties and the taxpayers, and to allow our workers to get on with the public service work we expect of them. Binding arbitration on all issues benefits everyone and would restore integrity to the system, and I encourage you to vote ought to pass. Thank you.
Thank you, Ms. Sanborn, for your testimony. Are there any questions? Chair recognizes Representative Drinkwater.
Thank you, Mr. Chair. Ms. Sanborn, for being here. You've talked a lot about the democratic process. If we include salaries and benefits in binding arbitration, couldn't that have an adverse effect on the local mill rate, which should be controlled by the elected officials?
I would not expect it to, because the arbitrator is required to take into account the resources of the municipal or public sector employer. So that has to be a factor. And I actually think that it's much more effective for us under our current system to be used as simply a training ground. Public sector jobs used to be highly regarded and the ultimate in obtaining a job because they had good benefits and you could be proud of having that job. And now they are among the most underpaid jobs anywhere. And what is happening in all of these, especially state departments, but also municipalities, is people are using these jobs to get a foot in the door. And as soon as they have a little bit of experience behind them, they're hired by private sector workers for $5 and more an hour more than they were being paid for the state. And I think that cost, in
Well,
addition.
yes, you've answered my question, and I don't
Okay.
want to take up anybody else's time. So
right.
thank you.
Are there any other questions for Ms. Sanborn from the committee? Seeing none, thank you very much for being here today.
Thank you.
Mr. Adam Good, the floor is yours.
Good morning, Senator Hickman, Representative Sylvester, members of the Joint Standing Committee on Labor and Housing. My name is Adam Good. I serve as the Legislative and Political Director at the Maine AFL-CIO. The collective bargaining process grows out of a recognition that there is a fundamental power imbalance between the individual worker and the corporation or employer. The individual worker on their own does not have power to have a strong voice to shape their conditions of employment. Collective bargaining seeks to address this power imbalance. And for that system to work, there needs to be a guiding set of fair rules. Working people should have a level playing field when they engage their employer in the collective bargaining process. Collaborative collective bargaining process should produce a labor agreement that benefits the employees, the public employer, and the community that they work for. As you've already heard today, in public sector labor law in Maine, when both parties cannot move forward, they enter into mediation. If that does not work, they move to fact finding. Both of these steps involve time, work, and cost to both parties. When both groups are at an impasse after fact finding and mediation, they go forward in the process to arbitration, where a 3-person panel reviews the issues at hand, seeks to reach a joint resolution, and if that is not possible, ultimately issues a decision. From the outset of negotiations, the employer knows that arbitration is only advisory and non-binding on economic matters of salary, insurance, and pension. Moreover, public employees do not currently have a legal right to strike. This means that a group of working people who want to negotiate for better salaries or retirement or health care can be thwarted by an employer who knows that drawing out the process, forcing workers to spend money on fact-finding, making it through the arbitration process will result in a recommendation only. In the end, the employer can ignore the outcome of arbitration on economic issues and impose a contract. This bill levels that playing field by making arbitration binding. To be clear, even under a system of binding arbitration on economic matters, neither party wants to go to arbitration because it takes time, costs money. However, if we're going to have this step in this final dispute resolution, it should be binding on all matters. Currently, employers have a leg up because employees can't withhold their labor in the form of a strike, and the employer knows that arbitration does not have teeth because they can ultimately impose. We like the provision of this bill where a public employer that does not enter into an agreement to carry out a binding determination made by arbitrators would have public employees be authorized to strike should they choose. A few moments left here. I just think lastly, I mean, these are a lot of jobs where people don't have a lot of control over their work, and to have mandatory overtime, to be exposed to traumatic events at work, to have a lot of competing demands on your family and personal life, and then also to not be able to collectively bargain in a meaningful way, just really kicks you while you're down. Appreciate your listening to my testimony.
Thank you, Mr. Good. Are there any questions from the committee? Chair recognizes Representative Rader.
Thank you so much, Mr. Chair. Thank you for being here, Mr. Good. Just a quick question because it was sort of setting off a couple of bells in my head. And my dog decides to bark right now. I apologize. I was specifically wondering about this bill's relation to last session's LD 990 and giving the public sector workers the ability to strike. So this feels like a little bit of a less extreme step than LD 990. Would you concur?
Yeah. We're talking about public servants who very much care about their work and care about their community. For any worker to strike is a very challenging moral decision. I think probably even more so in the public sector. And I think we represent a lot of affiliates and a lot of unions where they probably would never strike because of their relationship to how much they care about their work. I think not having binding arbitration on economic matters and not having the right to strike really makes it so the worker does not have any power in their workplace. And these are people that get calls in the middle of the night to go keep us safe. So, you're really at the whims of the employer without either of those things. And we think that if you're not going to have the ability to have binding arbitration on economic matters, the least they should have is the opportunity to withhold their labor if they're being taken advantage of, in their opinion. Of course, it's very complicated because there's lots of public sector employees who we know would never strike, and the employer probably would be able to call their bluff on that. So we think this strikes the right balance.
Are there any other questions from the committee for Mr. Good? Seeing none.
Enjoy your morning.
Thank you. Mr. Michael Kraus was signed up to testify in favor, but he is tending to an accident. And if he returns before we close the public hearing, we will take his testimony at that time. That's all I have signed up in favor of the bill. Unless there's someone on the attendee list who would like to testify in favor of this bill, please raise your hand at this time. Seeing no hands raised, we will now turn to testimony in opposition to LD 677. I'm going to begin with the department, Julie Armstrong, followed by Stephen Bailey, Scott Morelli, Roger Kraus, Robert Nadeau, Kate Dufour, and Julia Finn. So first we'll hear from the department from Julie Armstrong.
Can you hear me now?
Yes, we can hear you now.
I'm sorry, I got kicked off. Not an opportune time to get kicked off of Zoom. Okay. Thank you for letting me testify today. My name is Julie Armstrong, and I'm the Chief Counsel in the Bureau of Human Resources for Maine's Department of Administrative and Financial Services. And as you stated, I'm here today to testify on behalf of the administration in opposition to LD 677. Briefly, LD 677 would empower independent arbitrators to make final and binding determinations with respect to the expenditure of public funds for salaries of state employees and salaries, pensions, and insurance for all other state employees. And as you mentioned, would also, under certain circumstances, authorize employees to strike, defer the submission of cost items to the fiscal year after the contract is ratified. It's the position of the administration that salaries, pensions, and insurance comprise a significant portion of most operating budgets, and that the decisions to tax and spend public funds must remain in the hands of the citizens of Maine and their elected representatives. Turning over this responsibility to arbitrators, regardless of the mechanism of their appointment, runs counter to this principle of representative democracy. Private arbitrators are not elected and they are not accountable to the taxpayers or to the public. And for these reasons, the state has repeatedly rejected this approach to labor relations in the public sector, and really was the primary point made in the governor's veto message for LD 1177 in 2019. The administration is also concerned that this would have a detrimental effect upon the collective bargaining process itself. Labor negotiations could essentially become meaningless, as the prospect of binding arbitration of financial matters may undermine the parties' incentive to attempt to reach an agreement on their own. And we believe that the traditional give and take of negotiations toward an agreement by the parties without outside intervention is always more conducive to good labor relations. We would suggest that even though under the strike provision you have exempted public safety employees, we believe that a significant portion of public employees provide the necessary support to make it possible for the employees who work directly to protect public safety perform their jobs. And in short, we believe that the safety and well-being of Maine depends on public employees doing their work every day. And the thing that distinguishes public employees from private sector employees is the powerful voice they have in labor relations. They have the right to free speech and free association. They can lobby their elected officials, speak at public meetings and hearings, engage in informational pickets, hold rallies, press conferences, and write to the press. And in addition, as citizens, public employees elect the officials making these decisions about their wages, hours, and working conditions. And if they're dissatisfied, they can terminate those employees.
Letting you know that your time is wrapped up, if you're able to finish in the next couple sentences.
I can, thank you. So in conclusion, the people of Maine expect their elected officials to make final decisions on the expenditure of public funds and to delegate those decisions to arbitrators not accountable to taxpayers runs counter to that public responsibility. Thank you.
Yes, thank you, Ms. Armstrong, for your testimony. I just want to be clear. I think I heard you correctly. Are you saying that public employees tend to write letters to the editor when they may have some grievance with their employer?
I think I have read a few of those in my career. Yes, they do.
Thank you. The chair recognizes Representative Rader.
Thank you so much. And thank you for being here, Ms. Armstrong. I caught something in your testimony that sounded a little bit like kind of a catch-22 that we're in, and I just want to hear your opinion on it. You mentioned independent arbitrators not being accountable to the taxpayers that pay their salary because they're not elected, they're not appointed. That would firmly put them in one of the two camps that were entering into the arbitration then, wouldn't it? They would be state employees that would be subject to the contract, or they would be representatives of the state itself on the other side. So can you speak a little bit about that and why someone who is independent of that process is disfavorable in the mediation?
My concern isn't that they're independent of this process, it's that they are not accountable to taxpayers and to elected officials. So it really is the elected officials who should have the final say in the financial matters. The elected officials should determine what the tax rates are going to be for their citizens and how those revenues are going to be spent.
Are you good, Representative Rader? Thank you. Are there any other questions for the department from the committee? The chair recognizes Representative Drinkwater.
Thank you, Mr. Chair, Ms. Armstrong, for being here. Some of this come through a little garbled, but could you, if I'm picking up what you're putting down is, this could have the unintended consequences of affecting my local mill rate because of unelected arbitrators. Is that true?
That is true. And I will say that I have never been to interest arbitration as an attorney, but I've spent a career going to grievance arbitrators. And I can tell you that arbitrators sometimes can do the unexpected. And when arbitrators are not accountable to the elected leaders and to the citizens, we really don't know what we can expect. It sounds good on paper that they're independent and that maybe now under this bill, they would have to be residents of Maine. But I can assure you that sometimes arbitration can be a crapshoot. We don't know what we're going to have. We have a system that the elected leaders should be making these financial decisions for the citizens of Maine. And we think that works.
Thank you.
The chair recognizes Senator Mearmont.
Thank you, Mr. Chair. And thank you for being here, Ms. Armstrong. So it sounds like the legislator should make final decisions. And that's an argument for not having this, but can you think of any other situations where even though legislators make decisions that the executive branch ignores them, thereby affecting mill rates and that sort of thing, so that maybe this is a broader argument and not specific to this bill?
Well, speaking from the state as an employer, I would say it's the way the law is written now, it is up to the governor to negotiate the collective bargaining agreements. But the legislature has the role because it has to fund all the cost items that have been tentatively agreed to by the governor. So both the elected governor and the elected legislature have the voice, and the legislature has the final role on whether those cost items can be absorbed by the state.
Follow up, Mr. Chair.
You may proceed.
Thank you. Well, I'm just thinking that, say, particularly with the budget, which this would be part of for the collective bargaining, and then it's agreed upon. And then there's also a law that says that the state has to meet 55% of the EPS. And yet chief executive after chief executive keep ignoring that law, no matter what the governor, no matter what the legislature tells them. So this is like, you're using that argument against this bill, but it's really not about this bill. It's like anything to do with government and this funding and where it affects workers and it affects schools and it affects mill rates is pretty arbitrary from the standpoint of, say, the local negotiators on against the teachers, say, or the chief executive against the municipalities. So how does this argument really, how can you take it out of context and say it's about this when it seems so much broader? That's what I'm not understanding.
Well, you talk about the chief executive, but more importantly, it's the legislature that passes or fails to pass the chief executive's proposed budget. So ultimately, the legislature of the state of Maine makes that final decision on the state's budget and what part of that is going to municipalities.
Interesting. Thank you.
Are there any other questions from the committee for Ms. Armstrong? The chair recognizes Representative Gear.
Thank you, Mr. Chair, and thanks for being here, Ms. Armstrong.
My pleasure.
My question has to do with the idea of the panel of arbitrators that would be appointed here, making sure that they have, they are from Maine and they are appointed based upon their neutrality and their ability to do this kind of a job. I'm always struck by the situation where parties have reached an impasse and the ability of a set of fresh eyes, a neutral third party can come in and help to really move the discussion forward and find some common ground. At this, the way I've understood the process today, this would be after a lot of different attempts to do that. And I guess I would just look to you for further thinking on that, because the idea of having people that were selected for this job that do have that kind of a deep understanding of how these things work in Maine would seem to be really helpful in many situations. And I'm curious about your perspective on that.
Well, as you mentioned, under the current system, long before the parties ever get to interest arbitration, they also use the services of an independent mediator and then independent fact finders. And then ultimately, if they can't reach agreement, then they go to arbitration. And these arbitrators would not be employees. And I really think it's unrealistic to think that they would have a lot of experience with any particular employers and any particular relationships. There's someone from the outside. At least under the current system, these arbitrators are not paid much. And so I think oftentimes it's very difficult to get qualified people who want to volunteer. I think there's in general a problem with the lack of arbitrators in the labor field right now. I'm hearing from our labor administrators. And so yes, a fresh set of eyes is important. And under the current law, these advisory opinions are very useful. I think there could be political pressure on the executive, be it in state government or in any municipal or other organization, where an arbitrator issues a decision that becomes public that says the employer should do something that they're not or haven't been willing to do. And so that can be used effectively to encourage the employer to perhaps change their position. There's public opinion becomes part of the mix. And so I think the opinion of this person is what's important, but ultimately having this person decide what the taxpayers and the citizens of Maine are going to have to pay for taxes is just wrong and contrary to our system of democracy.
Can I have a follow-up, Mr. Chair?
You may proceed.
So thank you for walking me through that. That was very helpful. I'm thinking about, again, the situation where all of this various steps have been taken. And when it's come down to that final brass tacks kind of moment, assuming that someone with arbitration that was, vetted and approved for this panel would have the ability to find, given where we are, given that we've gone through all of this process, here's a solution that can work. And y'all just kind of sit down, come to the table, and we're done. Here we go. It seems like that would be certainly a better alternative than what's been described earlier, which is, the employer at that point being able to say, sorry, you have to take what we put on the table, you're done. And to the point that's been made about the festering dissatisfaction that can bring. Why is that necessarily a bad example, a bad alternative in that case?
Well, again, I think it's impossible with this proposed structure to get away from the fact that this person who's not accountable to the taxpayers will be making those decisions. But I think there's one more important thing to know, which is that once, under the current law, once the decision is made, which is binding on all non-monetary issues, and I wouldn't minimize the importance of all of those issues to the workforce, but the advisory portions of the interest arbitrators report is issued, and the employer and the union are required to go back to the table to negotiate in good faith pursuant to the law after this advisory opinion. The employer cannot say, we reject that. They have an obligation under the law and will be held accountable by the Maine Labor Relations Board to negotiate in good faith over this advisory opinion. And they should, if they're not willing to agree at the table, they should have a compelling reason why they can't agree as they're negotiating in good faith. So it isn't as simple as you receive the decision and you choose to ignore it.
Thank you.
Are there any other questions from the committee for Ms. Armstrong? Ms. Armstrong, are you able to speak briefly to the testimony from Mr. Tom Feely of MSEA about the wage gap?
I am. So the wage survey was, the market survey was one piece of a big compensation classification study that was authorized. And so a consultant was hired. It was, you heard about some in which the benchmark positions, so the survey had benchmark positions. So it's not every position in state government. And you heard about the ones where they determined that state employees were underpaid. That was not true for all classifications. And I apologize, I don't have all the details because it's part of the compensation classification group who handles that. But I will say that I do know that they did not consider the benefits of these employees. And as you know, state employees have a very generous benefit package, both in terms of insurance and retirement. And many of the classifications listed by Mr. Feely have the even more generous retirement packages for early retirement and reduced years, etc., for law enforcement, correctional officers, and so forth. And so those were not considered. So part of this process is to work through though that wage study as part of this bigger compensation classification system that we're evaluating to come up with the right system.
Thank you. And my final question for now anyway is, you use the term unaccountable to the taxpayers frequently throughout your testimony. It's my understanding that the employer is the state, which is us. The state employees are our civil servants, which are ours. And if it takes a third party to ensure that the terms of an agreement are fair, what difference does it make if the people who are doing that are not elected officials?
Given, I guess I would say that you and the governor and town selectmen, et cetera, are elected by the public to make those tough decisions. And the decisions are tough because the financial decisions affect all of the residents, the constituents, et cetera. And we'd like to assume that every arbitration decision is rational, reasonable, and fair, and is what this legislature would have done under the circumstances, but that isn't necessarily the case, and that's not our structure. So we do think it's very important not to remove that power from the voters who elect our officials. And as I said before, the voters can choose to fire these officials if they don't like the decisions that those officials are making.
Would you think it's fair to say that it's also in our best interest to make sure that the people who are working for us on our dime are satisfied so that they can do the best jobs possible for us?
I think that's a very important consideration. And I can only speak for the state, but I do believe that we work hard at trying to meet the needs of our employees and make our work sites good places to work. And we have, I think, relatively good relationship with the unions. We're in negotiations right now. I'm the chief negotiator for the state for the MSEA contracts, which, as you probably know, cover the vast majority of state employees. And so I think, and I can't speak to what's happening in pockets in the municipal sector, and I assume you'll hear more about that from other employers, but I think that things are working at the state level.
Thank you. Are there any questions? Chair recognizes Representative Geer.
Thank you, Mr. Chair. Just following on from something that you had just said, Ms. Armstrong, the idea that, say, an arbitrator would come in at the end and render a decision that was potentially very out of line with the taxpayers' expectations in whatever part of the state that was happening, in a way that would be, would just really stand out. I'm wondering how that person would continue as an arbitrator on the panel and or working in the state if that was the case. I mean, if you were coming in and rendering a decision that was clearly biased in some way, that would be a problem, wouldn't it?
Well, I didn't necessarily suggest that the arbitrator would be biased, but arbitrators, there is a wide range even within reasonable people who would differ. And arbitrators could have very different views of things. Some arbitrators tend to be more supportive of the union positions, some of management, some in the middle, and we can't really predict in a given situation what that particular arbitrator will decide, and this would be essentially non-reviewable. But again, it's the fundamental principle that it's not that arbitrator who is selected from a panel who will be making decisions that will hugely impact the tax rates of the citizens of the community or of the state of Maine.
Follow on, Mr. Chair, if I may.
You may proceed.
Yeah, and just to clarify on that, the purpose of the panel, wouldn't it be to select those arbitrators that were perceived as neutral and middle of the road as opposed to biased? Isn't that, I think that's a function of the panel in the bill, is it not?
I think that's designed that way, I will, as I mentioned before, there is a shortage of experienced arbitrators in the labor field. And I'm not sure what the compensation rates would be. The people who have been on the state panels in the past, the compensation rate is very low. And so the availability of effective arbitrators is probably challenging. And even with the administrators who administer grievance arbitration, these arbitrators can make up to and over $3,000 a day, which is not what the state board would pay. And it's still very hard. It's a bit of a dying field. So the practical reality is, it might sound okay on paper, but it's challenging to come up with a panel of arbitrators who would be everything we want them to be and would hope that they would be in reaching their decisions. And again, back to we think that it's fundamental that it's you and it's the elected officials who make those final decisions about what the taxpayers are going to pay.
Thank you.
Excuse me, are there any other questions from Ms. Armstrong? Seeing none, thank you for being here today.
Thank you.
Next up, we have Mr. Stephen Bailey, followed by Scott Morelli, Roger Krause, Robert Nano, Kate Dufour, and Julia Finn. Mr. Bailey, are you with us yet?
Yes, I am.
Good morning. The floor is yours, sir.
Good morning, Senator Hickman, Representative Sylvester, and members of the Labor and Housing Committee. I am Steve Bailey, Executive Director of the Maine School Management Association, testifying on behalf of the Maine School Boards Association, as well as the Maine School Superintendents Association, in strong opposition to LD 677. This bill combines two very bad ideas. One that betrays local property taxpayers despite their consistent support for local school budgets, and the other betrays our students by allowing teachers to walk off the job despite the fact they are operating under contracts negotiated by their union. Let's start first with the disregard for local taxpayers. School boards negotiate contracts with their teachers and other bargaining units based on what school employees want and the taxpayers can afford to pay. The legislature in 2019 passed a budget that called for ramping up minimum teacher salaries to $40,000 over a 3-year period. That certainly affected salary schedules, particularly in rural parts of the state, but our starting salaries needed to go up. This bill, however, goes too far and says that when the school board reaches an impasse over wages and benefits, it's time to call in an arbitrator. We can envision days of budget hearings where an outside arbitrator drives the discussion on how resources should be spent. That takes the decision out of the school board's hands and the hands of local citizens who elect the board and pay property taxes. We believe such a move will ultimately lead to failed school budgets, where not only teachers and staff lose, but also our students. The right to strike has a more dramatic and direct effect on our students. It betrays their trust in an important adult in their life and takes away important structures and support. It also very difficult on working parents. We are especially concerned about those students with individual education plans who, because of their unique needs, rely on specific school services that will not be available during a strike. Their parents rely on schools to help care for their children and provide that important instruction. I'll close by saying there are many other options to get concerns across to the school board and administration other than a strike or arbitration mandates out of Augusta. The most significant one is a good and effective relationship between the union and school leaders. We have been working together throughout the pandemic and believe collaboration is a much better solution for taxpayers, parents, staff, and above all, students. We'd be glad to take any questions.
Thank you. Thank you, Mr. Bailey. The chair recognizes Representative Drinkwater.
Thank you, Mr. Chair. Mr. Bailey, thank you very much. You used the word allows them to strike a few times in your testimony. Are you referring to what this bill about arbitration says? Can you direct me on where you're finding that?
Yes, it is included in a couple different places within the statute where it says if arbitration is not successful, then it does allow for the employees to strike. And that sentence is in there in a couple different pieces of the legislation.
Thank you.
Chair recognizes Chairman Sylvester.
Thank you, Mr. Chair. Welcome, Mr. Bailey.
Good morning.
So you suggested that rather than having any sort of legal ability at the table to affect the outcome of financial concerns, that unions should just have a good relationship and ask for as a favor to raise these things, or to, what exactly is the power of that relationship versus the legal powers enacted in this bill?
The legal powers are already enacted with the ability to be able to collective bargain. And in terms of the statutes that are already in place to be able to enact that. And as the previous speaker talked about, there are multiple opportunities for how that can continue its role, and the responsibility that boards as well as bargaining agents have to be able to, even after a decision by an arbitrator, to return to the table to find a fair and reasonable agreement.
But if that isn't being effective, then you just believe that the final say should just be with the employer, and that should be that.
That's the way the current statute is written, and I do believe that based on the school board's ability to work both with the residents of the communities to be able to identify what they feel they fairly can provide for compensation and insurance benefits for their employees.
Interesting. Thank you.
Chair recognizes Representative Rader.
Thank you so much, Mr. Chair. Thank you for being here, Mr. Bailey. You mentioned specifically students with individualized education plans and their parents. And as a parent of a child with an IEP, I'm struggling to understand the difference between the possible strike, the possible cessation of IEP, and what we're currently experiencing with remote school, because my child isn't getting the same services that he used to receive when he was in in-person school. So as a parent of a child that might be negatively impacted per your argument, we see this happen for a lot of different reasons. So I'm struggling to understand why that was an argument, a point of argument for against this bill.
Thanks for the question. The pandemic certainly wasn't something that was under our control. We do feel as if a strike would be under the control of the people who made the decision and took the vote to strike. And so in that particular instance, yes, services would be withheld from students based on their actions.
Chair recognizes Representative Gear.
Thank you, Mr. Chair, and good to see you, Mr. Bailey. I'm thinking specifically about that idea of arbitration risk, that the idea of getting to the end of a negotiation after many, many stages and steps with an agreement unreached is theoretically a threat to both parties. And under the current system, it would seem that that's really not a threat to the employer, because they know that at the end they can impose whatever they want at the end. Although I think in most cases, as we've heard today, they do want to, all parties would like to avoid the whole process if possible. And I guess I'm just wondering, again, if that incentive was there for the employer as well as the other parties negotiating, wouldn't that incentive provide a push for them to reach an agreement to avoid that final binding arbitration process?
It is possible. However, circumstances are different within each communities and with each of the communities that are served by the school boards. And I think in some of those instances, they find themselves in extremely difficult financial times. And to have an arbitrator be a determiner as to how the mill rate might be set locally or how taxes may be impacted by their independent decision, rather than have it be determined by what the school board felt was viable and feasible for their town is quite different, I believe.
Can I have a follow-on, Mr. Chair?
You may proceed.
In your experience, Mr. Bailey, are there negotiations where if there, for example, if there are extraordinarily bad financial circumstances happening, that the union negotiating isn't cognizant of that as the negotiation is proceeding earlier in the phases?
I believe in many cases they are aware, and in many cases that even there a collaborative approach is taken as to what the specific difficulties may be with regard to what's possible during any particular cycle of negotiations.
Thank you.
Are there any other questions for Mr. Bailey from the committee? Seeing none, thank you for being here, sir.
Thank you.
Next is Mr. Scott Morelli, followed by Roger Krause, Robert Nadeau, Kate Dufour, Julia Kern. Is Mr. Morelli with us, Ms. Thompson? Welcome.
Welcome. Thank you all. Appreciate your time. Senator Hickman, welcome back. Representative Sylvester and distinguished members of the Labor and Housing Committee. My name is Scott Morelli. I'm a resident of New Gloucester. I currently serve as South Portland City Manager, although I'm not here testifying on behalf of the city. Rather, I'm here to represent my views as a citizen and someone who's dedicated most of his professional life to public service with over 16 years of municipal experience. And I'm here today to strongly oppose LD 677. I highly value all public employees, union or non-union. And I believe that many union members would say that I've negotiated with them. When I've negotiated with them, I've treated them very fairly. I've even offered 3-year packages to unions that were so generous that they didn't feel the need to further negotiate. In this day and age, good pay and benefits are essential to attract and retain quality public servants. But the decision as to what that pay and what those benefits should be should continue to be up to the bargaining unit and the local officials, not distant, out of touch, unaccountable arbiters. And the elephant in the room here today is a simple question: why? What exactly is this big problem that we're looking to address? Is there truly a rampant issue with unfair decisions being forced upon union members in the public sector that have been so unreasonable as to justify this infringement on local control and home rule authority? I've heard nothing today or previously to suggest that such a drastic change to the law that has been in place for decades is necessary. While this bill doesn't seem to be addressing an issue that's endemic, there will be a slew of new problems that you will create upon its passage. Here are a couple of examples. If unions know they can just arbitrate to get a mere 2 friendly arbiters decide with them, what's the harm in going to arbitration all the time? If a union wants a 5% increase, but they were only offered 3, what do they have to lose by forcing arbitration? Worst case, they receive the 3%, but maybe they wind up with 4 or all 5. I believe this bill will lead to more arbitrations and more time and money spent by local officials in collective bargaining negotiations. Another example, a community facing a revaluation that will increase property taxes for residents by an average of 10%, and in some cases over 50%, decides for next year not to give COLAs to any employees so as not to exacerbate the tax shift. They ask the unions for 1 year at 0% and then to come back to the table the following year to bargain when finances are better for reopeners. The unions disagree, and an arbiter rules the community must pay a 3% COLA. In order to do this, taxes need to increase 5%, or the city must lay off 5 employees so not to increase taxes further. In each of these cases, a community has been forced to pay more than it can agree to offer by non-resident unaccountable arbiters. So in general, one of 2 things will always result: taxes increase or cuts are made elsewhere in the budget to cover the forced increase. This bill to me smacks of a solution seeking a problem, and I urge you to reject it. If you do not, I urge Governor Mills to veto this bill as she wisely did last session. I appreciate your time and thank you for your commitment to public service.
Thank you, Mr. Morelli. The chair recognizes Chairman Sylvester for a question.
Thank you, Mr. Chair. Welcome, Mr. Morelli. I'm curious whether you knew that the bill called for Maine arbitrators who were selected by the governor and would be a neutral, an employer and a labor arbitrator, rather than the last year's version, which just called for arbitration.
No, thank you. I appreciate that, and I did. I heard also President Jackson reiterate that. It's still a case though where someone from Madawaska and Rumford, could be deciding what happens in South Portland or New Gloucester, and to me that still seems a little bit not local control friendly.
Quick follow-up, Mr. Chair.
May I proceed?
Mr. Morelli, last year when this bill came forward, I wondered if you were aware that there were over 40 teachers and for the bill on public sector strike, over 250 teachers who came out from all over the state to express that there was a problem in this. I just wondered if that was something you were aware of.
I didn't, and I'll be honest, my focus mostly is on the on the municipal side, non-school side.
Okay, I appreciate that. Just you'd said it was a solution looking for a problem, and those folks seemed to think it was a problem. So I just wanted to make sure you were aware. Appreciate you coming out today.
Thank you.
Chair recognizes Representative Bradstreet.
Thank you, Mr. Chair, and thank you, Mr. Morelli, for being here. I just want to make sure I got encapsulate your testimony as well as I can. And so, are you saying that really a collective bargaining unit calling for a bargaining arbitration, the employees' unions really have there's really no big downside to calling for arbitration on their part, but on the employee side, there would be a downside to it?
Well, in the example I cited, if we're able to say, look, we've negotiated and we've wound up at 3%, but the unions still feel like they want 5%. 3% might be a reasonable offer to them, but what's the harm in bringing the process further to arbiters? All they have to do is get 2 of the 3 people to say that 5% or 4% or 3.5% is reasonable. Regardless of what the local finances and other unions have accepted, for example. So there's no real downside to going to arbitration other than, it's not super expensive. It is time consuming. And so if you can get a little bit more, why not try?
Okay, so they have nothing to lose by going.
A little bit of money to pay the arbiters, which, again, I've never actually been to this type of arbitration. I've done mediation. It's, relatively low cost, one that I'd wish to avoid, but yeah, there's really no, all that they would in theory be out would be that amount. At least they're going to get the 3% that was offered in that scenario.
Okay. Thank you for your testimony. Thank you.
Yeah.
Chair recognizes Representative Cuddy.
Thank you, Mr. Chair. Thank you, Mr. Morelli, for being here. Under the previous situation you just described, wouldn't it be possible for the arbitrator to find against the union and they could actually only get 2.5% or 2% if the arbiter is so found?
I think if we've offered 3, I think they can't go any lower than 3%. But to be honest with you, I wouldn't swear on a Bible or the Constitution to that. But that's my understanding is if we'd offer 3, it can't go any lower than that.
I would appreciate finding that out for the work session, Mr. Chair, if we could get that information.
Representative Cuddy, can you please make your request one more time for the analyst?
I would request that in arbitration, is it possible for the arbiter to find for a lower amount than has been agreed upon by the parties if they find that the economic situation justifies it?
Thank you. We are scheduled to take this up this afternoon, but we won't if we don't have all the information. So anyone who has any information requests for this bill, as Representative Cuddy has done, please make sure that we know what they are. Representative Bradstreet, do you have a follow-up?
No, I don't. Thank you, Mr. Chair.
Are there any other questions at this time? Seeing none, thank you for being here, sir. Next up is Mr. Roger Kraus. Welcome. Good morning.
Good morning. Thank you. Representative Senator Hickman, Representative Sylvester. My name is Roger Kraus. I'm here today representing the Maine Water Utilities Association to testify in opposition to LD 677. Maine Water Utilities Association is a nonprofit association formed in 1925, represents 109 water utilities across the state of Maine. I've submitted written testimony to you, but I'll highlight a couple of the points in that testimony here. LD 677 requires binding arbitration over salaries, pensions, and insurance, items that are presently subject to review by municipal boards. Requiring binding arbitration on these matters removes the fiduciary responsibility from the municipal boards and reassigns it to a panel of 3 arbitrators who are not responsible to ratepayers or taxpayers. The boards are elected by the voters to oversee the municipal budgets. Additionally, LD 677 allows public employees the option to strike. Employees in the water profession provide critical services affecting both the public safety and public health of Maine's communities. Imagine if a fire hydrant were not operable, a water main break were not adequately repaired, the water people drank every day was not properly treated, or if wastewater was not adequately treated and discharged because the employees responsible for these tasks were on strike. Significant threats to public health, property, and the environment are likely if these critical employees can strike or cause a work slowdown. The tasks performed by water and wastewater employees are vitally essential to the health and safety of our communities. Please do not remove this longstanding protection on the services we provide to the people and the communities of Maine. For these reasons, the Maine Water Utilities Association urges you to reject LD 677. Thank you for your time.
Thank you, Mr. Kraus, for your testimony. Are there any questions from the committee? Seeing none, thank you for being here today.
Thank you.
Next up is Robert Nato, followed by Kate Dufour, followed by Julia Finn. Mr. Nato, the floor is yours when you are ready.
Hi, can everybody hear me?
Yes, sir.
Thank you. Senator Hickman, Representative Sylvester, and distinguished members of the Joint Standing Committee on Labor and Housing. My name is Robert Pinetto. I am the Chief Counsel for Labor and Employment at the Maine Community College System. In my duties, I'm the lead negotiator on all 6 collective bargaining agreements for the Board of Trustees, the system. I'm writing on behalf of the system in opposition to this LD. This legislation would impede the ability of the system to fund ongoing efforts vital to the state. The bill would also imprudently delegate authority to set salaries to an arbitration panel that has no ability to fund the salary increase that they may approve. In addition, since the bill includes a right to strike, the bill potentially creates a financial and operational catastrophe for the community college system and the students that it serves. As a public employer, our ability to provide salary increases is properly controlled by the budgetary allocation the legislature provides to the system. Any salary proposal we make must be funded through state appropriation and/or increases in tuition. Currently, approximately 80% of the system's appropriation is used to fund wages, taxes, and benefits. If we negotiate a salary increase greater than the appropriation, we would undoubtedly have to reduce expenditures in other programming. The system uses the resources that it has to best serve the educational and workforce needs of the people of Maine, and the Board of Trustees, rather than an arbitrator, is better suited to make those decisions related to education. We believe that salaries of public employees should properly be addressed through the legislative process. As the legislature, pursuant to the Constitution, controls the purse strings, the proper venue to address salary deficiencies is within the legislative rather than the arbitration process. The legislature has the ability to address concerns related to wages and benefits for public employees. But unlike an arbitrator, the legislature also provides funding for the salaries mandated. An arbitration panel under this legislation would have the ability to impose an increase, but the arbitration panel has no mechanism to fund the increase. A salary increase by arbitral fiat would inevitably lead to layoffs, reduction in educational programming, and a curtailment in our workforce development initiatives. The LD does provide that, quote, cost items arrived at through arbitration must be submitted for inclusion in the governor's operating budget for the fiscal year following the fiscal year in which the agreement is ratified, end quote. This language, however, still leaves open the very real possibility that cost items imposed by arbitration will ultimately not be supported by appropriation that is included in the final budget approved by the legislature. In such a case, the community college system would be obligated to fund the increases through reductions in other programming. This bill, regardless of the language quoted.
Mr. Nato,
Yes.
unfortunately, that is the end of the 3 minutes. I wonder if you could sum up your thoughts.
If I could just make one more point, please. This bill does include a right to strike. We think the right to strike could create a financial catastrophe for the system, and we think that that could be in the neighborhood of $35 million, and we would present a physical note to that effect. Thank you.
Thank you for your testimony. The chair recognizes Chairman Sylvester for a question.
Thank you, Mr. Chair. Mr. Nato, thank you for being here today. I'm just curious, would the arbitratorial fiat take into account the finances of the city in making their decision as one of the major factors in coming upon that decision?
As I read the statute, Representative, the arbitrator is required to consider finances, but is not limited by finances. It is a factor that the arbitrator must consider, but the arbitrator would still have authority to exceed whatever financial limitation has been placed by the legislature. So it's merely a consideration.
So I'll just follow up on the line of thought that was earlier. Folks were bandying about 3%. Is it likely that a teachers union would bring it something to arbitration over 3%? Is it more likely that it would be a 1-0-0 over 3 years that they would bring to arbitration? In your experience, if you have experience in arbitrations of this sort?
We have never been to arbitration over salaries. We try very hard to meet the needs of our workers as we can within the budgetary constraints. But I would say that we have had proposals that have exceeded double digits in the past in negotiations. And I think that it's a very real possibility that we could be faced with an arbitration proposal, a proposal headed to arbitration that did exceed 3% or did exceed a more modest increase, as you're suggesting, if I understand your question correctly.
Appreciate that, Mr. Nato. Thank you.
Chair recognizes Senator Garrett.
Thank you, Mr. Chair. And I do have a question for our good testifier. Do you believe that this bill could cause tuition increases and the possibility of increased student
debt? I think that's a possibility. I'm also concerned that if an arbitrator were to impose a decision retroactively, that could force us to make a budgetary decision midway through a fiscal year, for example, where we would have very, very limited resources in order to impose or act on an arbitrator's decision. And we could be forced to take drastic measures, which I suppose could include some degree of tuition increase. I'm not sure, I'm speculating a little bit, but I would be very concerned that we'd be forced to take very drastic financial action in order to meet the decision made by an arbitrator.
Thank you.
The chair recognizes Representative Gear.
Thank you, Mr. Chair, and thank you, Mr. Neto, for being here. Following on from the points you just made about the seeing large increases proposed in contract negotiation. Again, I'm just wondering here, given the phases that we know about, so we've got the mediation phase, if you haven't come to an agreement, and then the fact-finding phase, and then this is just happening at the very end. Is it truly your belief that at that point you might be facing a large discrepancy in the salary and benefits piece of the negotiation that could be a large one as opposed to a small negotiating point?
Well, as I indicated, Representative, I've never had to go through binding salary arbitration before, but there are certainly examples from other jurisdictions where such decisions were made. And in fact, I quoted an arbitrator in my testimony. I didn't read this particular provision, but I quoted an example from an arbitrator in another jurisdiction who said that, you know, the financial limitations, the budgetary constraints don't really matter at arbitration. So it would be something that I'd be very concerned about.
Hold on, Mr. Chair.
You may proceed.
So yet again, I come back to the issue of the panel being selected. The idea here is that you would have arbitrators who were from Maine, familiar with our fiscal situation, et cetera. Are you speaking of those kinds of arbitrators when you give that example, or is that an arbitrator that is sort of on one side or the other of a dispute?
I can only you know, address the materials that I've read, so I can't be certain. But I would say that if we assume, for the sake of argument, that there is an issue here and that there is an issue with salaries, let's assume for the sake of argument that there is an issue with salaries. It seems to me the best means to address that is through appropriation, not through arbitration, which may or may not be tied to appropriation. If there is an issue, I think the best way to address it is through the appropriation rather than through arbitration.
I'm just trying to work the scenario a bit because I'm having a hard time understanding how a negotiation could proceed through the months of mediation and fact finding, et cetera, and still come to the point at the end where you've got, well, gee, we want 7 and you're giving us 3. It just seems highly unlikely to me that there wouldn't have been some back and forth and give and take already have happened at that point. So I'm trying to figure out if the example you're giving is something that's gone through that whole process with a truly neutral arbitrator that isn't saying, hey, well, I don't care about that financial stuff, which seems, again, very odd.
Yeah. Well, I can't, you know, I'm not sure I can speak for these arbitrators, but it would appear to me that having the benefit of arbitration, having this statute in place, would create an incentive for the unions to seek more, to make proposals that are not within the appropriation, because they would reasonably believe that the arbitrator is going to find a middle way between the management offer and the union offer. So wouldn't it create an incentive for the union to seek more with an understanding that in the end, the arbitrator will find a middle way? It seems to me that's a reasonable supposition given this statute, given this LD.
Thank you.
Yes, are there any other questions for Mr. Neto? I think it's an assumption, not necessarily a supposition. Can you tell me what you're going to base this huge fiscal note on that you mentioned in your testimony, sir?
If we were to face a strike, Senator Hickman, we could be in a position where we would possibly have to return federal financial aid to federal authorities. And if we were in that situation, if we were unable to complete a semester, for example, because of a work stoppage, and we had to return federal financial aid, we could be in a situation where we could be facing a liability of tens of millions of dollars and be faced with a suspension of services.
So that is an out, that's a scenario. A fiscal note has to deal with a reality. So how do you base an expensive fiscal note on an if? What number would you use if the circumstance hasn't actually happened in the fiscal year that you would be putting the fiscal note on?
Well, we can estimate what our federal financial aid for a semester would be. And we can estimate that if there were a work stoppage, what the amount that would have to be returned to federal authorities would be. And that is what the fiscal note would be based on, and actual numbers based on the federal financial aid that our students receive, that we receive, and that would have to be returned in the event of a work stoppage.
And that would be a narrative fiscal note then, not necessarily a numerical one in the budget.
I'm sorry, sir, but I'm not sure I understand the distinction between a narrative and numerative. But I think we would estimate those costs at approximately 35 million.
And have you seen any other jurisdiction anywhere else in the country have to return federal funds because of a strike, or does that not exist anywhere in the country, as far as you are aware?
Well, I would say that the notion of a public sector strike is limited because of the history and because of notions regarding public sector work stoppages. For example, if you look at the case that permitted public sector bargaining in the state of Maine, there was a specific reference made by the law court in that case to the fact that strikes would not be permitted by public sector unions. So I cannot think of an example at this time that meets your criteria, sir, but that's because work stoppages in the public sector are extraordinarily limited for a wide variety of reasons.
Thank you for that. We'll have to, Mr. Langland, if you could give us the law court case that Mr. Nando refers to. And so I guess my final question then would be, if this hasn't happened before, how do you know you'd have to return federal funds?
We've done an analysis based on our understanding of federal financial aid regulations.
And will you be able to present that analysis to the committee before a work session or at some point in the near future?
Yes, we certainly can.
I appreciate that very much. Thank you. Are there any other questions from the committee? Thank you for being here today, sir.
Thank you.
K24, the floor is yours. Welcome.
Thank you. Thank you. Senator Hickman, Representative Sylvester, and members of the Labor Committee. My name is Kate Dufour, and I'm here on behalf of the Maine Municipal Association to provide testimony in opposition to LD 677. Much of what is in our testimony has already been stated. So I just want to take this opportunity to underscore the responsibility of municipal officers, the elected select boards and members of the council, and their significant the heavy responsibility of balancing the needs of employees and programs and services, as well as the ability to pay. These programs, these services, these salaries, these benefits are paid by the property taxpayers, which is the most regressive tax that we have in the state of Maine. And so to the extent that the officers, those who are elected to run the community, would put that decision-making at risk is of great concern to municipalities and the property taxpayers. And this is particularly true as, this law would affect all public employees. And when you look at the property tax and what communities have to do, they have to pay their school assessment. So schools come in, we have to pay the school assessment. The county assessment comes in, we have to pay the county assessment. After we've funded mandates and provided services that we're required to, what is left is used by the community to advance municipal services, municipal desires, municipal needs. And that's often crowded out with the system that we have in place. And we're very concerned that if we take that risk and we are required to pay salaries over and above what we can afford, we have very, very few choices. One is to reduce staff, cut programs, increase taxes, or a combination of all three. So this is a very significant concern, and it really flips the policy on its head, and it takes that decision-making authority away from local elected officials and grants it to somebody who may or may not understand all the nuances that go into building a budget. It's not press a button and the budget is done. You have to have these conversations about what the priorities are for the community and what needs to be funded. So I thank you for your time and consideration, and we'll answer any questions you might have.
Thank you, Ms. Dufour. Are there any questions from the committee? Seeing none. Thank you for being here. And finally, Julia Finn.
Good morning. You must be speaking to the Judiciary Committee because I seem to always be the last person to testify. So I'll try to be quick. Senator Hickman, Representative Sylvester, members of the Joint Standing Committee on Labor and Housing. My name is Julie Finn. I reside in Portland and I represent the judicial branch. I have a few concerns I'd like to raise about the bill. In the bill, a new method of choosing an arbitration panel is proposed, whereby each party selects one arbitrator and they select the third arbitrator, or the third is appointed by the Labor Relations Board. The language in that part seems to take away the ability of the parties to agree on an arbitrator. Just wanted to mention that. And when arbitration is necessary for the judicial branch, our current practice has generally been to use one arbitrator rather than a panel. I'd also like to mention Part C regarding cost items. In this section, because our agreements are frequently not ratified by the members until July or August, we would not be able to include in the first year of a biennial budget the items that were agreed upon. Even if negotiations started much earlier, the ratification often doesn't occur until later. There's been a lot of discussion about a third-party arbitrator making decisions on salaries and benefits, and that putting that authority in a third party is something we also have concerns about. And then finally, with respect to the right to strike, when I testified before this committee in a previous session involving the right to strike, the concept of a partial emergency curtailment of court activity was purely theoretical. However, in March of 2020, due to the pandemic, we actually were forced to limit in-person court sessions where a person's safety or constitutional rights were at stake. Many other important case types, including family matters, small claims cases, and contested traffic cases, were also put on hold. Their circumstances were, of course, beyond our control, and these measures were taken to protect the health and safety of the public and our employees. But this necessary curtailment continues to create difficulties in the lives of many Mainers. An example of this would be a divorced couple with one young child and a court-ordered shared custody arrangement. If one parent refuses to share custody of the 3-year-old and the other parent files a motion to enforce the order, they might wait for an extended period to get into court. Presumably in this instance, no one is in danger, no one's constitutional rights are being threatened, but justice is not being served by the court system's limited schedule. If judicial employees were to go on strike, the citizens of Maine would be deprived of access to justice, and the pandemic has demonstrated just how serious those consequences are. Finally, as I mentioned earlier this session, Section 1294 of the Judicial Employees Labor Relations Act requires that the Supreme Judicial Court be consulted before that act is amended. This particular LD was not mentioned in the letter the committee earlier sent, and I just wanted to bring that to your attention. I think my time is up, and I thank you very much for your time and would be happy to answer any questions.
Thank you, Ms. Finn, for your timely testimony. I did not know you always went last in judiciary, so I guess that's a coincidence today. The chair recognizes Representative Bradstreet with the question.
Thank you, Mr. Chair. Thank you, Ms. Finn, for being here. Good to see you. So it's your opinion maybe that the ability to strike, the judiciary branch going on strike was given a brief picture of that by the pandemic, much like the school situation would be with parents being forced to stay at home because their schools aren't open. Okay.
That's right.
Okay, that's okay. Thank you.
Chair recognizes Representative Rader.
Thank you so much, Mr. Chair, and thank you, Ms. Finn, for being here. You mentioned that the judiciary used one arbitrator, is that correct?
Generally, yes.
Okay, and could you speak to the concerns you have over one arbitrator versus a panel of 3? I wasn't following the concerns there, so if you could help with that, that'd be.
It's not so much necessarily a concern. I mean, I assume there'd be a cost factor in paying 3 rather than 1, just to point out that our current practice has been used to use 1, and that often the one is agreed upon by both sides. And it appears that the law takes away that option.
Thank you.
Are there any other questions for Ms. Finn from the committee? Seeing none, that is all we have signed up to testify on this bill. If we have missed anyone in the attendee list, please raise your hand at this time. Seeing no hands raised, I will close the public hearing on LD 677. Is there any other information that the committee needs for the work session, either sometime later today or on Friday? Great. So it is noon. We are going to have a presentation from the department on the change package. I'd like to just take a 5-minute break right now. We don't expect that presentation to go more than 45 minutes, after which we will take a longer lunch break, and then we will come back this afternoon to handle all of the work sessions that we have on our agenda. So with that, we'll be at ease until 12:06. Thank you. It is 12:06, committee and attendees and listeners and onlookers. And we have Commissioner Fortman with us. Commissioner, is there anyone else that you would like to join you in presenting this change package, or are you all set?
The Deputy Commissioner, Kim Smith, is also available, and if there are questions, she may be helpful in providing some of the detailed answers.
Thank you. Yes, I do see that she has been promoted to panelist as well. And so with that, if you could go for it. We are all ears and eyes. Thank you so much for being here today.
Well, thank you so much. Good afternoon, Senator Hickman, Representative Sylvester, members of the Joint Standing Committee on Housing and Labor. My name is Laura Fortman. I'm the Commissioner of the Department of Labor, and I appreciate this opportunity to give you an overview of the items that are in the governor's change package to LD 221, and also to cover in a top line way some of the other initiatives in the Maine Jobs and Recovery Plan. Keeping in mind the administration's strong priorities are education, public health, our local communities, climate, our economy, and making good on the promises of state government. We have carefully crafted 3 proposals which chart a path for robust and widespread economic recovery and growth. First, the governor unveiled her Maine Jobs and Recovery Plan. The administration's proposal is to invest more than $1 billion in discretionary federal relief funds allocated to Maine under the American Rescue Plan Act. The proposal is meant to make historic investments in under-addressed needs and longstanding challenges to achieve 3 goals. The first is immediate economic recovery from the pandemic. The second is long-term economic growth for Maine. And the third is infrastructure revitalization. The plan draws heavily on recommendations from the Governor's Economic Recovery Committee and the state's 10-year economic development strategy. And these recommendations are transformed into real action to improve the lives of our people and strengthen the economy. And a summary of these investments is attached. And we look forward to collaborating with the legislature as we further refine these initiatives. As you know, we also presented a bond proposal aimed at rebuilding Maine's transportation system and conserving lands and waters. And then most recently, Governor Mills unveiled the Part 2 budget for FY 22-23. Thanks to Maine's good financial position, reflecting fiscally responsible moves by the governor and the legislature, the proposal makes historic investment in Maine's public schools and meets the state's obligations to pay 55% of the cost of K-12 education for the first time in Maine's history. I will now go into more detail about the budget proposal as it relates to the Maine Department of Labor. In the Maine Jobs and Recovery Plan, the department will contribute to the first 2 goals that I mentioned, investing in the immediate economic recovery and in long-term economic growth. As you know, minimizing tax increases has been an important part of the state's economic recovery. $294 million in coronavirus relief funds were transferred into the Unemployment Insurance Trust Fund to minimize tax increases in 2021. This year, the governor plans to transfer $80 million into the trust fund to minimize tax increases that would happen in calendar year 2022. Without the transfer of these funds, the current projection for 2022 would increase unemployment taxes by an estimated 60%. Long-term economic growth will require investment in research and development, skills training, and new worker attraction. Investments will be made to grow the healthcare and clean energy workforce. The department will lead the initiative to connect workers to job opportunities and will partner with other agencies and with higher education to increase the skills of Maine workers. The Maine Jobs and Recovery Plan, combined with the Part 2 budget, provide an unparalleled investment in Maine's workforce. I'm delighted that the change package to LD 221 includes a general fund investment in the department's career centers that hasn't been seen in 20 years. As you know, our career center staff work with people to develop individualized employment plans. These plans match people's skills and interests with jobs and industries in their area. These plans also identify resources to help people who are struggling with barriers that prevent them from participating in the workforce. To help meet the increased demand for employment assistance, the department is requesting 16 limited period career center consultant positions. These positions will be funded by the general fund through June 2023. The initiative increases the personal services line by $1.2 million in each fiscal year. The all other line is increased by $9,189 for technology and for the increased share of facilities costs. Unfortunately, this all other amount reflects the cost for only one position. The all other portion should have totaled $147,024. LD 2021 also contains other investments in Maine's workforce and completes the staffing changes needed for the Bureau of Unemployment Compensation. The department's initiatives are in the budget document on pages 153 through 160. Within the Center for Workforce Research and Information, 2 initiatives reverse earlier general fund reductions.
Commissioner Fortman, can you defer for 1 second? Mr.
Sure.
Logan, is it possible to put onto the screen for all of us to see as Commissioner Fortman talks about what's in the items so we can see it all together? Is that possible?
Would you like to see the change package document?
Yes.
Okay, you can give me 1 moment, I'll pull it up.
Great. Thank you very much, Ms. Smith. I think you should be able to share your screen. Perfect. Thank you so much.
Okay, so these are the initiatives in workforce research and information. So this is where it's reversing those 2 general fund reductions. And additionally, a 3rd initiative shifts the funding of a senior research analyst to the general fund. And this position had been vacant because of the decline in federal funding. And the reason that we're doing this is by increasing the appropriation for the Center for Workforce Research and Information is so that we can expand our analysis capacity specific to the workforce.
Thank you. Are there any questions for the commissioner on this item? Seeing none.
The next piece is within the regulation and enforcement program. And this increases the labor law enforcement capacity of the department. And it adds 3 labor and safety inspectors and 1 fraud investigator. And in addition, it includes additional staff support from the Attorney General's office.
Thank you. Are there any questions from the committee on this item? Chairman Sylvester. You are muted, sir.
Thank you, Mr. Chair. I just wanted to say that how pleased I am to see this and really feel, if you could thank the governor on behalf of the folks who put this in, I appreciate that. And I think this is going to be vital for our state in being able to help you and your enforcement team really both educate and enforce. And so I thank you for that. And if you would pass on my thanks to the governor.
Thank you.
You may proceed, Commissioner.
Okay. For the Bureau of Unemployment Compensation, which is what we're doing here, is there are 4 positions. One corrects the headcount and allocation for 6 positions. And so much of what we're doing here is making modifications that we talked about in the original budget document that were not accepted during that first round of funding. But basically, it's an allocation of different positions, and it is doing a reclassification that was funded internally. But at the end of this, it is it's the addition of 6 positions in the Bureau of Unemployment Compensation.
Thank you. Are there any questions about this item from the committee? Seeing none, please proceed.
And then the final initiative is it covers the Permanent Commission on Racial, Indigenous, and Maine Tribal Populations. And while the commission is not part of the department, its budget has been included with the departments, and the initiative invests in the commission's work to promote, implement, and coordinate programs that improve opportunities and eliminate disparities for historically disadvantaged racial, indigenous, and tribal populations in the state.
Thank you, Commissioner. Are there any questions from the committee on this item? Seeing none.
The other document that we included, Senator, that may be helpful is a chart that breaks down both the proposed funding for the American Rescue Act, the money that is in the budget, and the bond package as a side-by-side of populations that are impacted. I believe we provided that to your analyst earlier today.
And is that, Mr. Langman, is what the commissioner just referred to on the budget materials that you linked to us?
Yes.
Okay, great. And what is the title of that one?
It says how Maine's priorities are being met by sector.
Okay, let's just see how Maine's priorities.
Yeah, it is on, so on the webpage that I sent you, it says DOL presentation. It's like attached to the back of the testimony.
DOL presentation attached to the back of the testimony. Okay, well, at the bottom there. Yep, I see it. Okay, great. Thank you. Just for the clarity, so we can all see what the commissioner is referring to as we read this. We will certainly discuss this as a committee on Friday and give our recommendations to the Appropriations Committee about these changes. Are there any questions while the commissioner is here and the deputy commissioner are here? Chair recognizes Representative Bradstreet.
Yes, thank you, Mr. Chair. And thank you, Commissioner, for being here. I think earlier on you mentioned that because of the federal monies that came in, we'll be able to avoid a significant tax increase for employers. You said, I think something would have been around 60%. Will there be some, or has there been an increase from last year in the UI taxation?
So, Representative, thank you for the question. The taxes are for the next year, so for 2022, will be evaluated in September of 2021. So it's too early to give a definitive answer. We will see the assessment on taxes show up by the end of this month, by the end of May, so we'll have a better sense of that. But to be proactive, the governor included that $80 million, because we know that without an infusion, there would be a significant tax increase.
Okay, very good. Thank you.
Chair recognizes Representative Drinkwater.
Thank you, Mr. Chair, Commissioner Fortman. Thank you for your briefing. On page 157, the racial, indigenous, and Maine tribal monies, isn't this the same one in the original governor's proposal? She only wanted $500.
So that was a placeholder, Representative Drinkwater, for the commission, and just to allow the commission to accept resources. This is, I believe, has gone through lots of discussion and debate, and the new proposal does include the $498,000, just under $500,000 a year.
And is that federal money, or is that going to be general fund money?
That's general fund.
General fund. Thank you.
Chair recognizes Representative Cuddy.
Thank you, Mr. Chair. Thank you, Commissioner and Deputy Commissioner, both for being here today. The current state of the folks who are handling unemployment claims, how is that supported or altered going forward here?
Thank you, Representative Cuddy. What this does is we're adding a few additional positions into UI. In the part one of the budget was when we had the significant increase in limited period positions, and that has been approved and will carry through the next 2 years.
You good, Representative Cuddy?
I'm good. Thank you very much, Senator.
Are there any other questions for the commissioner today? Chair recognizes Senator Gary.
Thank you, Mr. Chair, and welcome, Commissioner. I was wondering if any of those expenditures are going to be spent in an effort to get people back to work.
Thank you, Senator. Yes, I think that one of the reasons that we have the limited period positions in the Career Center is because that is the focus of their work, is to do the outreach to the community, to help connect people to jobs, to work with employers, to do those matches. So we're very excited about that. And then in the American Rescue Plan, or the governor's plan, there's a significant focus on how do we help people get back to work and how to help employers get the employees that they need.
Thank you. Follow-up question?
You may proceed.
While we are on the subject of getting people back to work, I wondered if you yourself are doing any outreach, any TV interviews, anything like that, because we are seeing jobs posted everywhere and businesses having to cut hours because they can't find enough employees. So something that we could do for free, perhaps, would be having you be a spokesman for that.
Thank you, Senator. And I respond to calls from media on almost a daily basis. We're also running a PSA on several radio stations, providing information for how the services that we provide through the career centers for both employers and employees. And I'm open to other suggestions as well, Senator.
Thank you.
Thank you.
All good, Senator. Okay, the chair recognizes Representative Cuddy.
Thank you, Senator. And I apologize for a second question, but in your testimony, and I had meant to bring this up before, you talked about the all other line having been increased by $9,180, and this was, I believe, in reference to the Career Center changes, and then that it should have totaled the $147,024. Is that a change that is going to be made? Are you asking us to make that change? Because it seems important that that change get made.
Representative Cuddy, that is important that that change be made, and I would welcome your help in having that happen.
All right, and Senator Hickman, just to be sure about process, that we're going to be discussing this on Friday, and Friday would be the appropriate time to discuss that?
That is correct, sir.
Thank you.
Chair recognizes Representative Warren.
Thank you very much for bringing this forward, Commissioner, and your explanations. I'm wondering if you know anything more about why the decision was made not to fund the permanent commission during the supplemental budget, but was in this one. I know you mentioned that there were different talks or conversations, but I'm wondering if you're privy to anything and can give greater context.
I really can't, Representative Warren. If I was to say anything, I think that in the first part of the budget, it was focused on funding existing initiatives, and that the part two, after some of the reprojections, provided greater opportunity to fund additional programs and services.
Are you set, Representative Warren?
Yes, thank you.
Okay, thank you. Are there any other questions for the commissioner before we take a break for lunch? Representative Cuddy, are you good? Your hand is still raised. Just want to check in with you there. It looks like he is probably already at lunch. Well, with that, thank you very much, Commissioner and Deputy Commissioner, for being here today to walk us through the change package. We look forward to working with you to make this right as we move forward.
Thank you very much.
Thank you. So committee, we will take a break. It is 12:27. I'm going to ask us to come back at 1:15 so that we have a chance to get lunch. And if people will want to caucus in the new format that Ms. Thompson will send us the link to, that can all happen at whatever time folks decide to do that. But we won't start before 1:15 for our work sessions. We may even start a little bit later. That way we can just go through the afternoon well rested and fed. And so with that, we will see you all in 45 minutes, somewhat thereabouts. Thank you.